You're watching Behind the Headlines. I'm Pacchia. After months, if not years of discussion and debate in the media, the American Bar Association has finally issued a report on the challenges facing American law schools. Joining me now from Chicago to go through their findings, we have Brian Leiter, law professor at the University of Chicago and blogger at the Brian Leiter Law School Report. Welcome, sir. Thanks for joining us.
Thank you for having me to discuss this.
So 34 pages in total. Take it away. What did you like and what did you hate about this report?
Well, let me start on a very positive note, which is when you have a whole committee that produces a report, it's too many chefs spoil the soup. But here I think they've actually done pretty well.
Really?
It's generally well written. I think its basic recommendations are sensible recommendations. Occasionally the report sort of descends into sort of management speak mumbo jumbo, but that doesn't happen too often. So overall, I thought it was a pretty good, serious job they did.
That said, they have this disclaimer that says the report should be viewed as a field manual for people of good faith who wish to improve the legal education as a public and private good. Is that ABA speak for saying they're not going to do anything at all?
So there is always, I suppose, that danger. But some of the concrete recommendations, such as basically, the basic theme of the report is deregulation in the service of promoting greater experimentation in the delivery of both legal education and legal services. There's pretty concrete steps they can take to accomplish that, and so I think one should be hopeful that they will, that the ABA will in fact move in the right direction on these fronts.
What's your favorite recommendation in the report?
Well, I think the really crucial ones are to deregulate the requirements for being an ABA accredited law school so that we can have more experimentation in kinds of law schools that are out there. If you think about universities, right, and colleges, we have research universities, we have Harvards and Chicagos, we have liberal arts colleges, Swarthmore, Pomona, where the emphasis is more on teaching and less on research. In law schools, we've moved to a situation where every law school is supposed to be Harvard or Chicago, and that probably has not been good for legal education as a whole. Even medical schools recognize different functions. Even U.S. News & World Report registers that in medical schools. That is, they rank research medical schools separately from what they call teaching medical schools. And probably in law schools, we need more diversification of that kind.
Yeah, it's interesting, this concept of heterogeneity in law schools. You've written about it on your blog. I find it fascinating. You're right, law schools are different from other aspects of higher education. But why is it more desirable to have different kinds of law schools? Won't that make regulation of the entire space more difficult?
Well, I suppose it could. There's always unintended consequences in these things. I think the basic thought is that schools that emphasize teaching more than research are generally cheaper to run. And insofar as the elephant in the room here is the cost of legal education, creating more diversity of institutions offering legal education may have some effect on the cost. Though at the end of the day, we'll see what it is the market prefers, right? The reality is the biggest law firms recruit most heavily from the Harvards and Chicagos and Yales and Columbias of the world. That may mean that at the end of the day, the research-oriented model of legal education is still going to flourish. And the report acknowledges that as a possibility. On the other hand, it's a big world out there, and there is an enormous diversity of legal services that are provided and needed. It would make some sense to have more variation in law schools than we presently have to meet those other needs.
I also thought it was interesting that the report focused on how scholarships work, essentially pointing out that weaker students end up subsidizing their more talented peers. This is pretty fundamental stuff. I think it's great that they recognize a problem here, but what are they supposed to do about it?
Well, that's the tough question here. I mean, to some extent, that phenomenon of using tuition revenue to subsidize the students with the strongest credentials, excuse me, at a particular institution is itself a product of market competition. But this is, as it were, an unhappy consequence of market competition. Now, one thing that could be done, as a colleague elsewhere pointed out to me, is you go back 20 years to the Bush senior administration, and it was his antitrust department that clamped down on the Ivy League schools that used to collude on their financial aid offers. But because they colluded, they didn't get into this arms race of offering merit aid to go after the same few students. They offered much more need-based aid at that time. If the Justice Department wants to reverse itself on that, I have a feeling that would have a salutary effect on what can be perverse competition for the best students at the expense of offering need-based financial aid to deserving students.
It's an interesting dynamic you have here, because law schools are in competition against each other, but also law as a sector of higher education is also in competition with other sectors. I mean, law schools compete for talent coming out of the undergrad system against business schools and against med schools. So if you tweak the scholarship system within legal education too much, don't you run the risk of running a competitive disadvantage to medical schools and business schools?
I suppose that's a possibility. I guess I'd want to know more about what the facts are of what kinds of graduate education students are choosing between. I suspect we have relatively few students where the choice comes down to maybe I'll go to law school or maybe I'll go to medical school. We probably have more who are thinking about the MBA versus the JD, but without knowing how much that competition it really plays a role here, I'm not sure it's something we need to worry about too much. It's something the task force could look into.
So for those in our audience unfamiliar with how the ABA works, what's next in terms of process here? Where are we going to go after this?
All right, my understanding is they're going to have a series of public meetings to discuss the working paper. I believe the first one is coming up this Saturday. And they will, of course, receive lots of feedback on the working paper. We are in the process of giving them feedback on the working paper. At the end, I assume there will emerge not a working paper, but a final paper containing programmatic recommendations along the lines of what we see in this draft of the working paper. But some of this will turn on the internal dynamics of the particular committee, about which I don't know much, though, as I said, this working paper was a pretty thoughtful and serious piece of work, so I think that bodes well for the final outcome.
All right, Brian Leiter, thanks for your time today, sir.
Thank you.
If you'd like to learn more about the issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Pacchia. Thanks for watching.